Welcome to our latest webinar. This is part 3 of our mini-series entitled How Not to Lose an Employment Tribunal Claim. We had 2 earlier sessions, the first one very much looking at protected conversations and without prejudice. Last time we looked at some of the sort of tactical considerations that there might be in responding when you first receive a tribunal claim, and some of the preparatory steps that you might take in terms of preserving evidence and making sure that your witnesses are still around and available. And today we're going to look much more at the actual tribunal process itself, and in particular how much it's changed over the last few months. It's probably fair to say we've seen more change over the last 6 or 9 months in the tribunal process and system, certainly than we have in the last 6 or 9 years, and arguably probably more change than in the last sort of 20 or 30 years. So I'm delighted this morning to be joined by my colleagues Greg and Abby. And in terms of what we're going to cover this morning, we're going to look, as I say, at how the tribunals are coping in this sort of new normal, the types of hearing, including now sort of virtual hearings using the cloud video platform and other technological wizardry. We'll look at some of the practical issues for witnesses, how best to prepare, and then we'll share with you some of our experiences across the team in terms of dealing and managing with tribunals up and down the country. And then finally, we'll just have a look at a couple of options, how maybe to avoid a formal employment tribunal hearing altogether, look at judicial assessment and mediation. So if I may, I'll now just pass over to Greg to give us a feel for how employment tribunals are coping. Thanks, Greg.
Thanks, Rustin. Good morning, everybody. Yes, I suppose it's a very simple question on the face of it, and a simple answer certainly initially. Tribunals, how are they coping? Well, in March, April, May, the simple answer was pretty badly because they just weren't set up to deal with virtual hearings. So there was a struggle in the initial part of lockdown. What we had from the President of the Employment Tribunal for the period from lockdown to the end of June was this national listing direction. And what that said is that if you had a hearing, whether that's a preliminary hearing or a final hearing during that period, it was automatically converted to a preliminary hearing by telephone, which typically was then just to rearrange a date for a final hearing or for the next hearing and a timetable leading up to it. So initially, everything was done by telephone, just preliminary hearings, and during that period from March, April, May, June, that's what we had in place. Then in early June, we had a roadmap published by the President for the use of what's called CVP. Now, CVP stands for Cloud Video Platform, and we'll talk much more about CVP. But it's the HMCTS, the Courts and Tribunal Services platform they use for virtual hearings. And they had set up during June around 150 CVP rooms. So the tribunals across the country had 150 rooms that were available for use by the Employment Tribunal Service. And what we saw come the end of June was a very mixed position across England and Wales, with some tribunals being set up and running remote hearings under the CVP straight away, and others just simply weren't there. They didn't have the technology, didn't have the judges with the ability to use the platform because they hadn't had the right training and so on. So just reflect for a second the combined pressure in terms of getting used to technology with the number of claims that are coming into the system. And you'll see there that for single claims, and what I mean by that is where you have a single claimant, you might have multiple claims within their claim, but a single claimant, an employee bringing a claim. In 2018, there were 19,000 new single claims. But in March 2020, that number had increased dramatically to 36,616. So that's a massive jump, partly because of the removal of the tribunal fee system 2 or 3 years ago. But the reality is that we're also now seeing an influx of new claims, obviously because of the pandemic and related to the pandemic and redundancies. But come March, we were up at 36,000, and its forecast at that stage was to rise by 1% a week. 1% doesn't sound like much, but it is a lot. And so there's this huge pressure on the tribunal system, which is leading to quite substantial delays. And during the course of this morning, we'll talk to you about what that actually means in terms of delays in the tribunal. So if you do have tribunal claims that are ongoing and they're at the early stage, you know what to expect in terms of potential timelines. What happened in the last couple of years also is that because the claims were on the rise anyway, there was a round of recruitment in terms of extra judicial resource. And what we've seen in the last 2 years is we've seen judges' numbers in terms of salaried judges. They've recruited another 57, taking total to 130. But also there's fee-paid judges as well, and another 67 of fee-paid judges have been recruited in the last 12 months, taking the total to 230. So there's been a real push on recruitment. The only difficulty has been is that the fee-paid judges are only just starting to sit now, because the training that they were due to undergo, the induction during the summer, had to be postponed because it was a residential course and they couldn't do it online. So where we are right now is that we do have additional judicial resource, both in terms of salaried and fee-paid judges. So that should benefit and ease some of the pressure in the tribunal system. But as we sit here now, we are certainly finding that there is a huge amount of delay, both in terms of the administration of tribunal claims and also hearing them and taking them to final hearing. What the tribunal service had to do was prioritise claims, and certainly they have been prioritising claims related to dismissal and detriment cases on health and safety and protected disclosure grounds. These were prioritised because these were typically ones brought by people who were either shielding or on furlough, who had the immediate need for their claims to be heard because of the circumstances of the pandemic. So what we have now is presidential guidance issued in June, and it distinguishes between different types of hearing. So there are still cases being heard in person, where everyone attends as normal. To be frank, I haven't heard personally of anyone in the team having a full in-person hearing, but that is a possibility that it could still happen. Second type of hearing is a wholly remote hearing, and certainly that's what we're seeing most of at this stage, where everyone is attending through the cloud video platform, and they are sitting at home or in their office with the judge at home or in the tribunal room, but everyone's in a virtual environment. Sometimes the tribunal is allowing what's called a partly remote hearing. It's a hybrid, as you might imagine, where you've got some people attending in person and some attending remotely. And typically what you would see in that scenario is the judge and the legal representatives in person in the tribunal room, with the witnesses attending remotely. The guidance makes clear that it's for the judge to decide what type of hearing there will be out of those three options. And a listing will be sent to the parties, and the parties are entitled to write to the tribunal and make representations as to why, if it's been set as, for example, a fully remote hearing, why they might want it as a hybrid hearing, and vice versa. There's various factors that the tribunal has to take into account to decide what type of hearing to list it for. And just taking you through some of these factors, these may be relevant to claims that you are dealing with. Firstly, looking at the actual tribunal itself, they all will have been risk assessed, but they have different degrees of space. So, for example, you go into Croydon, you'll know that there's a large waiting room. There's probably 10 to 12 tribunal rooms, but other hearing centres across the country are much smaller. And if you go down to the West Country, for example, I went to Truro many years ago, that's a very small hearing centre. So the point there is that some hearing centres will have the capacity to have parties and witnesses in separate rooms potentially. Where it's located in terms of accessibility is relevant as well. So if everyone's going to need to get to the hearing centre by public transport, then that might be a factor going against it. So in London Central, the tribunal hearing centre is right near Holborn. May be difficult to get there other than by public transport. So London Central hearings, and certainly the ones that I've dealt with, have all been remote so far. Technology is a factor, absolutely. Has everyone got the right hardware and software? I heard of a case recently where the claimant didn't have a laptop for their virtual hearing, and the tribunal asked the employer to provide the claimant, the ex-employee, with a laptop, which did happen. So there's lots of unusual requests and flexibility because of the circumstances we're in. The factors also include the length of delay that there might be if the hearing is going to be held in person, and personal circumstances, legal representation, and an important one is the nature of the disputed evidence. If it's a factually straightforward claim, then it might be that the tribunal takes the view that the need for it to be heard in person is less important. But if there's lots of disputed evidence, and the benefit therefore of hearing and seeing face to face a witness give evidence might lean towards it being held in person, in a face to face environment. Okay, and what we must remember in the tribunal system is that it's a public hearing, and one of the things that the tribunal service has been keen to ensure is that that quality of public access, of open justice, is retained. It's a fundamental principle of not just the tribunal system, but all the court system in the civil courts. So they've been grappling with how to ensure public access, and what can happen and does happen and has been happening is that members of the public can drop into virtual hearings. What the member of the public can do is they can contact the tribunal, they can find out what cases are in the list, they can ask for access details, and they can then log in and listen to any virtual hearing. So we have seen that happen. Not that common, but it's a possibility. So what could happen if you are having a virtual hearing is at the start of the hearing, you could find the judge asking who everyone is, and the judge establishing that there might be 1, 2, 3 people who are just members of the public, or it could be the press. So that could still happen. One of the things that the judge has got to then consider is how can they ensure that the person, the member of the public, can see everything that everyone else can see. So that comes into play in terms of witness statements, and one option judges can use is to share their screen, and they can scroll through a witness statement on their screen, allowing the member of the public to read it. Alternatively, they could ask the witness to read out their statement. And just finally, and this is important, perhaps if you've got a tribunal claim coming up for hearing, we always say to our clients that it's really useful if witnesses can view a tribunal hearing, a live tribunal hearing. And pre-pandemic, I'd always say to my witnesses, go to your local tribunal if you've got the time for a day and just sit in some hearings, get a feel for the environment, hopefully see some cross-examination, get a feel for that. In the virtual world, it's all online, as I say, but the CourtServe website, the details are there on the slide. That's a website that gives details of all civil cases being heard across England and Wales. And if you go on the employment tribunal section of that, you can then click through to the different tribunals. So I could do that now and find out what tribunal cases are being heard tomorrow in the various tribunals. You could then contact a tribunal in reference to a particular case and ask for the login details if you so wish. So it's useful to always bear that in mind, particularly when you've got witnesses who haven't done this before, which not many people have, certainly not in a virtual environment. So I do encourage you to make use of that. Now I'm handing over to Abby to deal with bundles and the actual giving of evidence in.
Thanks, Greg. Yes, so I'm going to look at the next section on the different types of rules that have been published on documentation and the practicalities of managing bundles, what needs to be done now sort of going forward, and giving evidence. So it is all a bit different when it's remote, and how best to prepare witnesses for giving evidence, what useful tips there are. So the starting point in terms of bundles and documents is that the tribunal now prefer electronic documents to paper or printed, whether or not the case is ultimately going to be in person or remote. And that's for two reasons. Firstly is the immediate reason of the pandemic and electronic documents making things safer because they're not physically handled. But secondly, to support the operation of remote hearings. So things may not be listed for matters may not be listed for a full remote hearing, but there may be instances where a judge has to be replaced at the last moment and could potentially only attend remotely. There may be partial remote attendance. It allows the flexibility in the tribunal system to have partial or full remote hearings at the last minute if cases come out of the diary because they've settled, for example. So the tribunals are really trying to encourage that flexibility, and electronic documentation and bundles are a way of facilitating that. But they do recognise that a lot of the users of the tribunal, particularly unrepresented users, are not familiar with this process, and there will be an element of catching up and familiarising with this type of technology. So they've issued some guidance in terms of putting together electronic documents and how they like it presented. And that's predominantly for parties that are professionally represented, albeit that they would like unrepresented parties to do what they can to present things in an electronic format. And we've put up on the slide some things that are the principles of the electronic ordering and presenting of documents. So the tribunal would like pages containing text to be subject to what's called optical character recognition, and that is the process by which text, either typed or written, can be searched and highlighted. That allows a judge or panel member, or indeed the advocates, to search a bundle quickly and go to keywords or phrases in the bundle. They would like the index to be prepared with hyperlinks where possible, so that they can click on the index and be taken straight to the document rather than scrolling down the bundle. And pages to appear the correct way up. So we've been used to physical bundles where you might have to turn it to one way to read a spreadsheet, for example. If there are landscape documents like that, then they need to appear in a portrait mode and still be readable. So that can be a bit of a challenge depending on what the content of the document is. And significant documents need to be bookmarked. So, for example, the dismissal letter, any grievance, anything that's critical to the issues in dispute should be bookmarked so that the tribunal judge and panel members can go straight to those documents. Moving on. It is often the case in tribunals, many of you will be familiar with this, that documents come up at the last minute, perhaps after bundles have been agreed, potentially submitted to the tribunal, but they are relevant and need to be added. If that's the case with an electronic bundle, the guidance is that all particular tribunals need to be contacted to ascertain the way in which that they want the document to be added to the bundle. Each tribunal will have their own view on how they want that document to be added. And that's because sometimes the judge has already started looking through the bundle and marking their copy up. So they may want the document to be added at the end, for example. So if that is the case in any case that you're dealing with, make sure you contact the tribunal to ascertain how they want that to be incorporated. If a bundle is particularly large, then do think about how that's going to be transmitted to the tribunal. They can't really cope with anything above 20 megabytes. So if that's the case, if your bundles are larger than that, they'll need to be split up and sent separately. So you need to think about that in terms of how it's ordered and how easy it then is to put together at the other side by the tribunal staff. Parties, particularly represented parties, clearly will need to speak to unrepresented parties to assess their facilities, whether they are able, if you make up an electronic bundle, to read that bundle with their software, and they can navigate around that. So there will be an element of liaising at an early stage to ascertain what the technology is of any unrepresented parties. And as Greg's mentioned, it is still a public forum, so members of the public can request to inspect that bundle and those documents. Moving on, paper and printed documents haven't gone away. There'll still be a need for them for a variety of reasons, including whether an unrepresented litigant can read and have access to an electronic bundle. There's some guidance about measures in place during the pandemic period to reduce the risk of infection that do need to be taken into account if you've got any upcoming litigation, because it is slightly different to what we've been used to, and it would be helpful if your witnesses understand the slight differences so that they are fully prepared. So unless there's an arrangement for each separate participant to wear their own gloves, there will need to be separate sets of documents, such as bundles and witness statements, so that each participant is only handling their own set. I think more commonly we've heard of gloves being required rather than separate sets of documents. But because that is a change, it's very important that witnesses are aware that they may need to put those gloves on, and it's a slightly different process. Oaths and affirmation cards mustn't be shared, so they'll be read out instead. And the handing up of documents, which have been quite used to in litigation in the past, will only be permitted where safe handling arrangements can be made. So things like single-use gloves. And if you need to send documents to the other side or a witness, 24 hours is required, so it can allow for safe handling of those documents. And sometimes the tribunals will still order that paper copies of the bundle are provided, whether or not the hearing is going to be fully remote, and they need to be sent a week before the hearing so that the tribunal has time to rest them, if you like. And on that point, when you're putting together the electronic bundle and printing out the bundle, it's often the case that the page numbering can be a little bit knocked out. So that's something that's really important just to watch out for. Now, moving on, witness evidence. We've put up a poll question there about whether you feel that witness evidence being given remotely would be more or less effective. We know from speaking to clients that witness evidence is sometimes the principal concern that clients have. So we'll wait for those results to come through. Interesting. So 36% more effective, 64% less effective. And I think that very much aligns with conversations we've had and the fact that it is very new for full hearings to be fully remote. And we're all sort of getting used to the technology. So how do we make our witnesses more comfortable, more prepared when giving evidence, so that they can give the best evidence possible. Well, as Greg said, cloud video platform is really the way in which full hearings are now being heard, and for that they will need to have an appropriate device with a microphone, a camera, and how many devices they need will very much depend on the number of documents that they're going to need to look at. So it's almost, we would suggest at least 2 devices for giving evidence remotely. One with your camera and your microphone, so that you can present the evidence, and another one so that you can look through the documents, so that you're not having to flick between screens. You may even want a third if you want to have your witness statement on one, the bundle on another, and then your other one to actually speak into the camera and give the evidence. A stable internet connection is required. It sounds silly, but if you're at home where there's a lot of other family members downloading things using the internet, that's potentially going to affect the internet connection, and you know, we've heard of witnesses freezing when they're giving evidence because of the strain on their personal internet connection. It sounds silly to mention it, but professional attire is really important still. There can be a little bit of a relaxation, I suppose, where witnesses are giving evidence from their own home. They haven't quite got the same gravitas of going into the tribunal, but professional attire is still really important. And having that uninterrupted space to give evidence. So thinking about where they're going to provide the evidence. And if they haven't got that at home, do they attend your offices to the purposes of giving evidence? Is that going to be more suitable? What about the lighting? You know, if they're sitting in front of a window, that might obscure their face, and of course facial expressions are going to be even more important, which we'll come on to in a minute. And what do they have in the background? It is a public hearing. There could be any number of people watching. Do they want to have pictures of their family in the background? You know, things like this to talk about with them in advance, so that they get into the right mindset for giving evidence. It's really important, as in a normal in-person tribunal, that they don't have anyone with them that are guiding or influencing their evidence. And a judge may ask them at the outset whether they have someone with them. They're entitled to have someone with them, but the judge may want to see them on screen or have them sitting behind, so that it's very clear that they are not being influenced at all by giving evidence. The bundle and the statement that they are working from needs to be unmarked. So it needs to be exactly as it's produced to the tribunal. And we have heard on a number of occasions where witnesses have marked up their own bundles or statements, and they're not working from the correct ones. And that is then something that has to be flagged and changed and pulled up by the judge. So it's really important that they're aware of that. And also that they remain under oath during any adjournment. It's a difficult and different environment at home, you know, but they may be giving evidence up to lunchtime and then having a break, and they may be tempted to ring up colleagues or other people involved in the tribunal, but they remain under oath and they mustn't talk about their evidence at any point whilst they remain under oath. And it's a criminal offence to record any remote tribunal hearing. So that will be made clear to the witnesses at the start, but they should also be pre-warned about that. So I think a lot of the nervousness that our clients have experienced on remote witness evidence is whether the cross-examination of the other party, of the other side, will be as effective. I think there's a concern potentially that they will be less intimidated if they are having questions remotely, whilst they're not in the formal tribunal environment. I think that's probably not as much of a concern as perhaps people are have expressed, because advocates are now very much more used to cross-examining remotely. Judges are also much more used to hearing the evidence and the cross-examination remotely, and there is a sense that witnesses could potentially drop their guard on cross-examination because they feel a little more comfortable being at home. And it's also important to remember that witnesses will appear much closer to the judge as a result of giving evidence remotely. So in a tribunal in person, they might be several meters away from where the judge is sitting, and the judge will be able to observe their full body language, which perhaps isn't quite the case remotely, but their facial expressions will appear a lot further away in person. That's not the case with a remote hearing. Their facial expressions will be an awful lot close to the judge, and they will be looking at that. So I think cross-examination is still effective remotely. And moving on, in terms of the preparation for the day, there are some tips that we've put up there on the slide. The first one being to plan communication channels. Representatives will need to have a way of contacting witnesses on the day, remotely or otherwise, and often that is by way of WhatsApp groups or other things. But do remember that when you are a witness and under oath, you will need to come out of that WhatsApp group. Switch your camera off and mute yourself after any preliminary issues. We have heard of witnesses who haven't done that and have said things off camera where they haven't muted that they wouldn't want the judge or anyone else to hear. Do speak slowly. It's even more important than in person, I think, to speak slowly and clearly, and ask if you're not following where things are on a particular in a bundle or in a statement. And as with an in-person hearing, it is still possible, perfectly possible, to request a break if the witnesses need that. So they shouldn't feel that they have to stay seated if they need a comfort break, for example. So I'll hand to Greg now with you, some of our experiences.
Okay, thanks, Abby. So just pick up on a couple of points and add to a couple of points, just bring some examples into play. So Abby talked about the fact that it's important to have a suitable device, but perhaps have 2, maybe 3 screens. So you've got everything you need in front of you. Ideally, I think witnesses would have a clean bundle and a clean copy of their witness statement printed out in front of them. I did a hearing a couple of weeks ago, London Central, but a virtual hearing, where the claimant, who was legally represented, nevertheless was giving evidence, and he only had the documents on his mobile phone. So the process of him giving evidence and me cross-examining him became very, very slow, because I was asking him to open up certain PDF files, and he would have to take his time to open it up and then find the right document, the right part of the document that I was asking him questions about. It meant that it was a very slow process in terms of his evidence itself, but also from a witness's perspective, it's then he's in danger of getting confused and having to jump around and have the pressure of the technology. I mean, it seems quite a basic thing, but hopefully most of you will get your witnesses fully prepared with hard copies of documents and their witness statements, but make sure that they have the appropriate devices and technology. And a second point was around Abby's comment around not having people influencing in the room. And we heard of a situation it was around June, July time of a tribunal hearing where there was a lady giving evidence, and her husband was actually was in the room, but he wasn't actually on the screen. What happened was that the judge could see his reflection in the window behind his wife, and he was gesticulating to her as she was giving evidence. Well, that was totally unacceptable, and the judge picked up on that. But you hear of these instances which I suppose slightly amusing, but actually the judge will be very sharp to pick up on those sorts of things. So just going through the slide, just in terms of our experience of what's happening in practice. Firstly, in terms of the administrative side of the tribunal, so dealing with correspondence, what we found over the last few months is substantial delays in correspondence being looked at and then correspondence being responded to. So take, for example, if you are waiting or expecting a tribunal claim from a particular individual, and whereas if they are up against the 3-month time limit, you might think, well, 3 months has passed. If we don't hear within 2 to 3 weeks of a claim, then we think we've got away with that one. What we found is tribunal claims taking 6 to 8 weeks. Sometimes more, but probably up to 6 to 8 weeks before, for example, an ET1 will be sent to an employer. So you can't breathe that sigh of relief for quite some time in the current environment, because it might have been lodged and it might just be being waiting to be processed. In terms of corresponding with the tribunal, I mean, often there's correspondence that needs to be made with the tribunal in relation to any matter. Could be an application for something that you need to make to the tribunal. The only way of getting any sort of response would be firstly to mark your correspondence as urgent, but it needs to be genuinely urgent. And urgent in the tribunal's mind is if there is a hearing listed for the next day or two. So that will get their attention in my experience. But if it's marked urgent, but it's something that actually isn't that urgent, then it won't get dealt with quickly. So you need to bear that in mind. Tribunal staff, the admin staff, they were under-resourced anyway. They're still under-resourced and they're up against increased volumes of work. So it is a very frustrating time for parties where the sort of experience of the justice system isn't a particularly positive one at the moment. In terms of listing, and this is how long it's going to take to get the litigation concluded, we're in a mixed environment, let's put it that way. Different tribunals seem to have different levels of delay. So let me just talk you through some examples. Certainly in this region, in London and the South East, if you have, let's say, a 1-day unfair dismissal claim, which is issued now, you would get the ET1 sent to you, and you often would get a listing for a final hearing listed at that time that you get the initial paperwork, probably 12 months hence. And I had one issued in October, where we've just done the ET3, and we've got a final hearing date in the autumn of next year. So you're looking at 9 to 12 months for a straightforward unfair dismissal 1-dayer. If you have a discrimination claim issued against you, if it's issued now, you'll probably get, when you get your initial paperwork, you'll get a listing for a preliminary hearing, which would probably be in June or July. This is in London South as well. And you'll be looking to 2022 before you'd get any final hearing on a multi-day discrimination or unfair dismissal claim. London Central, we've had claims issued and listed for preliminary hearings and final hearings when the ET1 has been sent to the parties. But in terms of the timing, it's pretty similar picture to London South. So you would be waiting to the back end of next year for a straightforward claim to be heard and concluded. I had a claim in East London Tribunal, which was a preliminary hearing last month, and The tribunal had listed it automatically for a 2-day final hearing, and they found a slot in June of next year. We went back to the tribunal and said it's going to be a 6-day hearing, and the tribunal agreed once we'd made representations, and our 6-day hearing is listed for March of 2022. And East London, anything beyond a 2-day hearing, so 3-day hearing or more, is going to be well into 2022. This creates obvious problems in terms of additional costs. There's practical problems in terms of witnesses and whether or not they're going to still be in the business and still be inclined to give evidence so far forward. So things we need to think about now in relation to issues you might be dealing with in your businesses at the moment. Other tribunals in Birmingham, we're looking at probably PHs again in May, June for discrimination claims. So different pictures across the country, but it is one of fairly substantial delays. The other thing we're seeing is last minute decisions. So we've heard of a case amongst one of the team where it was all listed and the parties were all set to go to tribunal. Last minute it's converted to video. Well, that's, in some ways you may not think that's a bad thing, but then suddenly witnesses who might be slightly apprehensive anyway have got to start thinking about how they give evidence by video as well. And it is a different environment, and it is a difficult environment because it's not a very dynamic environment. So it can swing both ways as to whether it's easier or more difficult for witnesses to give evidence by video. Okay, Ruston.
Greg, thank you very much. So a couple of questions that have come in just as you and Abby have been speaking. So question for you, first of all, Greg, if I may. Who do you think is more likely to succeed as a result of the changes that you've been talking about, the move obviously to remote hearings? Do you think they favour claimants or respondents more, or is it not as simple as that?
I think the answer is it depends who's as it always was the case. It's about preparation. You know, we can't emphasize enough when we talk to our clients who have a tribunal claim. If our witnesses are very well prepared, if they know their statements inside out, if they know the documents inside out, they come up to proof, by which I mean that they actually stick to their statements when they're giving evidence and being cross-examined, then they're in the best possible position to succeed. And that probably would be easier in a virtual environment because it's harder for the advocate to use their skill in cross-examination in a virtual environment because it is less dynamic. When you're in a tribunal room as an advocate, your challenge and the skill is to, I guess, to muddle and confuse the witness. It's harder to do in a virtual environment because it's much more stilted. You have to ask your question and you have to make sure that they've heard it and wait for them to then deliver their answer. In the actual live environment, in a tribunal room, it is more dynamic, and there's more skill, I think, in terms of the cross-examination in that environment. But the answer I'd always say is about preparation. And you know, when I've come up against a claimant in a virtual environment who hasn't been well prepared, then they just look silly. You know, the guy that I cross-examined last month, he was there on his phone, trying to look at PDFs on his phone, hadn't even bothered to print out the documents, and it just came across badly. His evidence then came across badly, and fortunately we were successful.
Thank you, Greg. Abby, a couple for you, if I may. Can witnesses be part of a WhatsApp group during a remote tribunal hearing? I think we probably know the answer to that, but there's probably a thing to develop on that in the context of witnesses being part of a WhatsApp group. You know, with an upcoming tribunal hearing, do you make them part of a WhatsApp group?
Yeah, I think it's an interesting question. It's about trying to recreate remotely the experience that you would get if you have an in-person hearing, I think. So, you know, the waiting room in the morning, being able to pass up notes to the advocate, and how to replicate that. And I think things like WhatsApp groups can do that to a degree. They need to be very careful, and the representatives and the advocate will, of course, be very careful that they come out of any group whilst they're giving evidence and under oath. But as a sort of a mechanism of making them feel comfortable, sort of that waiting room sort of environment, they can be very helpful, I think.
Thank you. Yeah, I think it's a really interesting one. I guess, of course, the risk is, isn't it, that one sets up a group and that there's a bit of chatter on it, even in the period leading up to the hearing. And yeah, it is a tricky one. Another one for you, Abby, if that's okay. Does a party have to agree to a remote hearing, and what are the sort of the dynamics and the sort of considerations there for people?
Well, typically the tribunal will ask the parties whether they are capable of attending a CVP hearing for a final hearing. I had a question last week on a new claim asking both parties exactly that question, and for the parties to then respond by a particular date prior to it being listed. And that's really a tribunal getting a sense of, where can we fit this in? If the parties say, yes, we'll do it by CVP, then probably that would be listed slightly earlier than an in-person hearing. But they will consider all the things that Greg touched on in his section earlier on about the ability of the technology that's available, the type of claim, whether it's very document heavy, and of course the parties can make representations as to why they feel an in-person hearing would be more appropriate, and that may be where there are complex documents to go through and to explain, or the issues are such that they feel that an in-person hearing and having the panel there together would be more beneficial. But I think if it's a straightforward, let's say, unfair dismissal claim with not particularly document heavy, and the parties both have access to the technology needed, then it might be slightly harder to make those representations that actually an in-person hearing is absolutely necessary.
Thanks, Abby. Yeah, I think that's right, isn't it? And I certainly suspect that most lawyers, given a substantial case, would be saying that their client could be at a disadvantage, or in a sense they can't make the most of their case. Greg was talking about the skill of the advocate. You're obviously there talking about some of the sort of other considerations. I think, I'll ask a question really to both of you. Do you feel that the tribunals have a direction of travel on this, in terms of staying now with CVP? So in other words, almost, is the default going to be CVP unless you can show a really, really good reason otherwise? What do you both think on that? Abby first.
Yes, I think that is I think it's here to stay. The presidential guidance has, suggests things that are trying to tackle the immediate pandemic, but they're also looking forward beyond that. And I think the direction of travel very much in that guidance is we want the ability to do things remotely, and we want the ability to change from in-person to remote at the last minute. So I do think it's here to stay.
Greg, what do you think?
Yeah, just to add, it must be, it must be here to stay. And also from a user's perspective, if you've got a multi-day case and you've got several witnesses and they're coming from different parts of the country, potentially, it's going to be much more practical for them to stay wherever they are and give their evidence remotely. So I think from that perspective that it's here to stay. The other thing I was just going to add is that it's worth noting that in the ET1 form and the ET3, they've now been amended with a specific question to the claimant and to the respondent as to whether you're able and willing to have a remote hearing. So you can sort of, now you're flag to the mast at an early stage, and most people will say that they are happy to have a remote hearing, but that goes into the ET1 and the ET3 at that early stage as well.
Yeah, that's really interesting. Thank you both. We've got about 10 minutes left, so if we can, we'll move on. There are a couple of other questions. As ever, we'll pick them up and we'll circulate a sort of Q&A sheet to everyone that's registered today, and we'll do that over the next few days. But the last section now is really just on maybe how we can avoid the tribunal hearing altogether. And this, I suppose, is really looking at some of the options there. And the options really that we have would be looking at how we can use what's called judicial assessment, how we might look at private mediation, and similarly how we might look at judicial mediation. And there are sort of elements, pros and cons, and obviously differences to each. So first of all, looking at judicial assessment, well, this is something that was born out of a past unregulated practice of employment tribunals giving an indication. And you might get that at a variety of stages. You might have got it at a directions hearing, or you might have got it fairly early on day one, or indeed part way through a tribunal hearing, where an employment judge would basically say to the parties, well, would it be helpful if I gave you an indication of what the tribunal are thinking? Of course, as with most things in life, sometimes it was helpful, sometimes it was very unhelpful. And of course, depending on which end of that you were as a party, you either thought it was a good thing or not good, because sometimes the tribunal hadn't heard any evidence at all. Sometimes they just read the claim form and the response form. Sometimes maybe they'd heard a little bit of evidence, but of course they hadn't heard everything. They hadn't heard what both sides had to say. They hadn't seen the witnesses being sort of cross-examined. So this was really increasingly criticised as being unsatisfactory and undermining the appearance of a fair hearing. So that practice effectively sort of died out, and effective employment judges were told not to do it anymore. And then we had some presidential guidance a few years ago, really outlining when it should be applied, how it should be applied, and some of the conditions. Well, as a general rule, it will be the case that it's looked at in the during the preliminary hearing, the sort of case management discussion, when you're looking at sort of directions. And normally it's the case that the parties will both have indicated that they would like some form of judicial assessment to be made. Now, of course, at that stage, the judge won't really have heard or seen any evidence. So it will be very much impressionistic, very much looking at the claim form and at the response form, probably at the pro forma now that we have to use for the agenda for the sort of case management discussions. It's been very helpful in some cases, but again, of course, it's imperfect. If you have an unrepresented party, and to be honest, that goes both ways, whether it's an unrepresented claimant or an unrepresented respondent, sometimes the judge giving a firm but friendly view can be helpful, and it can press on towards possible settlement discussions or possibly a claim being withdrawn. But I wouldn't want to overemphasize the effectiveness of that. So it won't really be suitable, I think, where the parties are particularly entrenched in their views, where a lot of the evidence comes down to he said, she said, and at the end of the day, it'll be a question of looking at the credibility of witnesses. And again, it's unlikely to be helpful where there are very complex technical issues to be looked at, or where a case is particularly document heavy, where, if you like, in order to make that assessment, you have to go through the documents and work it through. Because the general view is that the case management hearing, preliminary hearing, shouldn't be much longer as a result of needing judicial assessment. So it's a sort of a 10-minute, half an hour period, not really longer than that. There are, of course, tactical considerations about deploying it and deploying your arguments, if you like, before an employment judge in the context only of a judicial assessment. Do you give too much away? And then the final one there, the practical issue, which is one that runs through all of these, which is how will you actually document and formalize the agreement? Because you won't get an employment tribunal to make an order or a determination as a result of a judicial assessment. You're going to either need ACAS or another lawyer's involvement through a settlement agreement. So moving on then to mediation options, and to workplace mediations, they can be helpful, obviously, particularly where there's an ongoing employment relationship. And similarly, judicial mediations were originally set up very much to focus on where there was a continuing employment relationship, and the idea of essentially sort of resolving a dispute in a semi-formal way, but allowing the parties to continue. But in terms of mediation options, again, of course, there's also the possibility of a private mediation. They are pretty uncommon in the employment tribunal context, but my view is that they will increase over the next few years, and there will be a number of reasons for that, and we'll come on to those perhaps just in a moment. So looking at the key features, obviously, of mediation, and forgive me, many of you will be aware of this, but mediation obviously has to be voluntary, both parties wanting to enter into it. It is effectively a series of without prejudice discussions and conversations. It is private, so it's not a public hearing. So unlike a main hearing, Abby and Greg were both talking about that, people able to see documents and other things. A mediation is a private process. It obviously has a greater degree of flexibility because obviously with a formal process, ultimately a court or tribunal is going to determine the specific issues that are, as it were, in front of it. They don't, if you like, have the latitude to kind of say, well, look, we'll find for you over here on this point as long as you agree to do this over here. Whereas obviously in the context of a mediation, if you like, a formalized negotiation, that can happen. Of course, there is an element of the mediation being a bit of a dress rehearsal, and there's good and bad perhaps about that. Sometimes one can feel, if the mediation has failed, that, well, that was a bit pointless. I've shown the other side my hand to some degree, and then cost and time. I've spent time and money doing it. On the other hand, as a dress rehearsal, to be honest, it can also be helpful in sort of perhaps ironing out some of those issues where you think, actually, our evidence on this point is going to need to be stronger, or indeed, we maybe get a sense of where the other side's likely to sort of press certain points. The private mediation, obviously, you've got the issue of finding the appropriate mediator, needing to agree who that is with the employee, and that can sometimes be kind of quite an issue. You probably have to look at sort of 2 or 3 options and try and agree. You'll then have to work out a venue. If both parties are represented, it's probably easy you end up in one of the parties' offices, are probably sort of okay with that. Otherwise, another venue, whether it's the workplace or elsewhere, but of course then cost comes into play, both in the context of the venue and of course the mediator. Process tends to be something that the mediator will largely control, albeit with input from the parties. But you still then, if you do reach some form of agreement, need to work out how to conclude that binding settlement. As I say, either probably through ACAS or more likely in the context of a private mediation through a formal settlement agreement. Now, as I say, they're relatively rare at the moment in employment situations, but I think they'll become more prevalent. And I think that's partly because tribunals are massively overloaded. They were overloaded and been starved of resource even before the COVID pandemic. You know, the prospect of a case or a claim that's not going to be here for 2 years or more. Obviously, that's a tactic that to some degree an employer can use, but also it's an issue that's kind of hanging about. And I had an instance recently where it was very helpful to be able to look at private mediation because the business was going to be sold. There was a potentially substantial claim kind of hanging over it. The seller actually wanted to crystallize the issue because otherwise, obviously, the buyer was going to chip the price. So it was sensible to get a resolution. And that had to be done, obviously, more quickly than the employment tribunal was able to provide. Judicial mediation, well, we had some presidential guidance in 2018, sets out a clear process in terms of how it's supposed to work. It's very much the case that the judge, employment judge, decides whether or not your case is considered suitable for judicial mediation. Originally, it was for claims where there was an ongoing employment relationship, and particularly claims in the discrimination space. And that's largely because discrimination claims tend to be very long and they can last sort of weeks at a time. And so very much the idea is, well, if we could have a day or at most 2 in judicial mediation, we could save maybe 3 weeks of employment tribunal hearing time and resource. But it is available across all the employment tribunal jurisdictions, although strictly not all cases will be considered suitable. The obvious exceptions would be equal pay, or where you've got multiple claimants or insolvency issues. Generally speaking, judicial mediation won't be thought appropriate there. At the case management meeting for the case, that's really where both parties have to put forward their position in relation to judicial mediation. And if the judge considers it's appropriate, then effectively you'll get a separate set of directions that deal with how to prepare for and how to hold the mediation, judicial mediation itself. There are some timing considerations in there, some tactical considerations about when it is best held, because you are trying to save a degree of time and cost. You're also trying to avoid the parties getting even further into the bunker. On the other hand, you tend to want to know what the other side has got in their locker. So very often you might look at judicial mediation immediately after disclosure, or possibly before if it's a very document heavy exercise to save that sort of time and cost. There'll generally be a separate bundle just for the judicial mediation, and usually there'll be sort of positioning statements and sort of schedules of loss and counter schedules. So there is quite a lot of preparation that judges tend to order. So it's not the case that it's just, okay, we'll have a mediation and you'll just turn up on this day. There is quite a lot of prep to do in advance. I think the benefits of judicial mediation are very much around, it works if the parties' mindsets, and that's both parties' mindsets, are sufficiently open to it. Like anything that's sort of broadly voluntary, as it were, the parties have to want to play, they have to want to seek a solution that route. Certainly beneficial in the context of time and getting a resolution more quickly. There is a degree of formality to the process, which again, to be honest, I think is helpful because it concentrates the parties' minds. And the judicial mediations I've been involved in, which I have to say have all led to essentially sort of settled disputes. You do get that sense of investment, I think, from both parties. There is an interesting dynamic. For the first couple of hours, very often you feel like you're going nowhere. Then the judge probably gives you both sides a good talking to. And then there's a degree of, well, if we spent this time doing this, let's try and get to some resolution because it avoids much more time and cost later on. So there is often a sense that the parties want to have something to show for it. So I think that's good. I think in the context of a claimant particularly, it gives them sometimes the sense that they've had a day, or exceptionally two, for a judicial mediation. They've had a day in court, if you like. They've gone to a formal process. They've heard what a judge has said. The employer has had to turn up and similarly sort of been part of the process. So I think psychologically it can be quite helpful. You still have that issue of the mechanics of the agreement and how will we achieve the settlement. Usually with a judicial mediation, it will be with ACAS's assistance, but again, the mechanics there of having an ACAS officer who is ready and available. Alternatively, you're looking at a COP3, and again, if the claimant is represented, of course, the issue of a settlement agreement is much easier because they'll have a representative who's able to give them the advice. So I don't know whether we've had any more questions on that section, Greg, or whether it's time to wrap up now.
We haven't on mediation. There's just one more question that came in. The question is this: can you object to a member of the public looking at a witness statement of documents in the bundle online? A concern there about confidential information or documents and privileged documents. My answer to that would be that it's difficult to object because the documents before the tribunal are there in a public forum. Privileged documents probably wouldn't be in the bundle anyway because they would be privileged. But you do need to factor in as the parties that if there are commercially sensitive documents in the bundle, which there almost always will be, that they are potentially available for the public to see and to hear what they contain. That's always the risk of a tribunal hearing because it is a public forum. Other than that, I think we've answered the other questions, Rustin.
Thank you, Greg. And thank you, everyone. I'm aware we've obviously just run over past 11 o'clock. I'm hoping that you all found that helpful. As I say, we'll put the Q&As together and have the recording, etc. up on our website next week, and we'll send you a link. I hope you'll be able to join us for the final webinar of 2020, which is going to be a brief roundup of some of the case law and legislation, and also a look ahead to 2021 in terms of what we expect. And I'm also told that some of my more inventive and imaginative colleagues will help design a short Christmas quiz. So that'll be in 2 weeks today. I think we're going to run it around about tea time, sort of mid-late afternoon, probably a little bit more relaxed than usual, but it will again be on Thursday. So it'll be Thursday, the 17th of December. So thank you all very much, and have a good day.